Lord Waldegrave, can I invite you to look at a document circulated by Mr. Canavan on the 12th of December 1990. So it's the day after the ministerial announcements that we looked at before lunch. The covering minute is DHSC 0003511_036. It's not, I think, a minute that's sent to your office, but what's said in the text of it is I attach a copy of the Secretary of State's statement in response to Harriet Harman and a copy of the Q&A briefing, which contains more detailed information about the government's position on settlement of the litigation, funding and distribution of the 42 million. It's now for the plaintiff solicitors to obtain agreement of their clients to the proposed settlement. And then if we can just look at the Q&A briefing, which is DHSC 0003511_039. But before we look at the one part I wanted to ask you about in this document, would you have received a Q&A briefing prepared in association with the filing of a written answer?
I don't think so, no.
Well, in any event, the point I want to ask you about, I think, is a more general one. If we look at the bottom half of the page, there's a question just over halfway down, why then are you settling the litigation? And there's an answer about the very special circumstances of HIV-infected haemophiliacs, reference to combination of the hereditary condition, and then through nobody's fault develops the tragic infection of AIDS, reference to the two earlier McFarlane Trust payments, and then it says this: ministers have now decided in principle, in light of the proposal, that the plaintiffs should drop their litigation to make a further ex gratia payment. And I just wanted to ask you about this idea of an ex gratia payment in contrast with compensation. It's right to understand, isn't it, that what was being paid pursuant to the settlement that we've been talking about was not intended to be compensatory, to compensate for the actual suffering and losses that the individuals had and would continue to suffer.
I think that's right. I mean, I don't think any amount of money can really compensate, but I understand in legal terminology this was an ex gratia payment.
As a matter of history, that last sentence is not entirely accurate, is it? Because it wasn't the plaintiffs saying they would drop their case, they were settling it. It wasn't a further ex gratia payment, it was a payment in settlement, albeit with the denial of liability. And the implication is it's part of your keeping, or not you personally, but the government, keeping a promise to keep the position of the McFarlane Trust under review. That's the link. So it's just not right, is it? In relation to what's happened?
Well, Sir Brown, I'm in danger of getting into a muddle about legal terminology and so on. But as far as I was concerned, what we were doing was accepting the plaintiff's proposal of a settlement.
Yes.
And I'm not sure that I think this is more complicated.
I don't really see why it's been presented in this way. That's it's not your problem because you didn't draft it, you didn't see it, you didn't endorse it, but it's been put out, and it just surprises me a bit. I don't know if we know anything more about the genesis of this, do we?
Other than that it was circulated by Mr. Canavan on the 12th of December, no. I don't know whether we have anything which shows whether he was the author.
Questions for him in that
yes,
case.
Precisely. So Lord Waldegrave, I think, again, it's right to understand that what was being paid, and leaving aside the question of how you phrase the route by which one got there, it wasn't ever based on any assessment of the extent of the need, the extent of the suffering, the extent of the financial losses that individuals might sustain year after year or decade after decade.
I do not know whether further back there had been such analysis, but certainly nothing was presented to me of that kind.
Now, I just wanted to ask you a little next about what I think you referred to earlier as the further spat with the Treasury in the spring of 1991. We touched on it with Mr. Mellor, so it's really just to get your take on what happened. If we pick it up at DHSC 0003659_032. This is a letter dated the 11th of March 1991 from Mr. Mellor to you. It refers in the first paragraph to some correspondence from Ian Lang, who was the Secretary of State for Scotland. We'll come on to the role of Scotland, Wales and Northern Ireland in the discussions in a little while. But there was an issue that had been raised about some extra funding to cover legal costs, essentially. And we can see Mr. Mellor setting it out in paragraph 2, third line. He says, I've already made £42 million available from the reserve to meet payments to the Macfarlane Trust. Do not envisage the amount will be increased. And then there's a reference in paragraph 3 to Mr. Lang having asked for reconsideration of the question of meeting legal costs from the reserve. Mr. Mellor continues in the last sentence of paragraph 3 to say you've taken provision in spring supplementaries of £42 million to make a payment to the Macfarlane Trust, possibly during March. Can you just assist us with what the reference to spring supplementaries is?
Well, when expenditure that hadn't been presented in previous years or previous supplementaries put before, supply estimates put before Parliament, you would have had to make a special one because all expenditure has to be put before Parliament.
And then we see Mr. Mellor in paragraph 4 saying it now appears that the other much smaller costs, particularly in the case of the territorial departments, are likely to fall in the next financial year. I can see little reason why such relatively minor costs cannot be met from within next year's existing provision, particularly since you have advance notice. You are aware of the difficulties we have had to face on public expenditure this year. It's already clear that next year will be no easier. I must therefore ask all three departments to absorb these costs. So in this letter, Mr. Mellor is saying no to any additional provision from the reserve for these additional costs identified. Can we then just pick up your letter in response at DHSC 0003660_007? This is you on the 25th of March 1991, back to Mr. Mellor. If we just go a little further down so we can see the text. So in point 2, you express concern at the line Mr. Mellor was taking about meeting legal costs. You set out your understanding as according with that of Mr. Lang, namely that compensation costs and reasonable legal expenses for the plaintiffs would be made available from the reserve. And in the last sentence of that paragraph, you say, I must thus ask you to maintain your earlier agreement to meet legal expenses from the reserve. You then say in paragraph 4, as your officials have been told, it is now improbable that payments will be made in this financial year as the legal process has not been completed. Therefore, the £42 million can be surrendered this year, but will be required from the reserve in 1991 to 1992. I trust you can agree to this. Now, is this right, Lord Waldegrave, that when you'd had your original discussions with Mr. Mellor back in December of 1990, it had been envisaged that it was likely, although not, I think, guaranteed, that the further discussions that were necessary to iron out the full details of the settlement terms and to secure agreement of individuals, the hope was that would be completed within the financial year, so that the reserves that you were utilising would result in payment out before the end of the financial year.
I think that's certainly so, though I think even then there was some talk about some of it being in one year and some in the next.
Yes. I think we may see that in a later letter. But the process of finalising those discussions had taken longer than perhaps anticipated. And so is this right? You were therefore saying we don't need to call on the reserve for the £42 million by the end of this financial year, which was by this point presumably imminent, but we will need it for the reserve for the next financial year.
Next year, yes. What I was standing on was the clear commitment that one way and another it would come out of the reserve.
The response you had from Mr. Mellor to that indication is at CABO 5044_008. This is Mr. Mellor writing to you on the 28th of March 1991. And if we look at paragraphs 2 through to 4, he says this: I was very disappointed to learn that the matter cannot be wound up, at least in England, this financial year. Officials have explained some of the background to this delay. I trust that the problems which have arisen will not put the settlement itself in any danger. As you are aware, the reserve for 1991 to 92 is already under considerable pressure, and he sets out some of those pressures, picking it up in the last sentence of that paragraph. Accepting an additional claim of £42 million at this stage would make it all the more difficult for us to deliver our plans. It is normal practice that access to the reserve is only granted when there is no alternative. I must therefore ask you to make every effort to contain most, if not all, of the grant within your existing programme, and to return to me later in the year only if you are unsuccessful in absorbing all of it. I would then be willing to consider without commitment a claim for up to £42 million. I understand that you will not wish to put patients' care in danger as a result of absorbing any costs, but by no means all of your programme is directly concerned with the treatment of NHS patients. I'm afraid that whatever happens, I cannot agree to access to the reserve for any legal costs or further payments to unknown claimants who may come forward. These sums are marginal, and I must insist that they be absorbed. We don't, I think, need to go over the page. So, Lord Waldegrave, is it right to understand from this, Mr. Mellor was saying to you two things. One is, you're not getting any more, so you're not getting anything to cover the costs, the additional legal costs and so on that Mr. Lang and you had raised. But he's also saying, I'm afraid I'm not even going to guarantee you the £42 million from the 1991 to 92 reserve. Try and find that from the Department of Health's existing budget.
Well, to coin a phrase, that vexed me.
Yes. And I think we see that perhaps conveyed in some of the later materials. But that is your understanding of what Mr. Mellor was suggesting. If we pick matters up just in a internal Department of Health minute to your private office, DHSC 0003662_101. So this is the 19th of April 1991 from Mr. Kendall to your Principal Private Secretary. I'm not going to read through the detail of it other than to note in paragraph 2 reference to another minute, which we can look at if we need to. Mr. Dobson's submission of the 18th of April is linked to this issue, as it indicates that we're very close to the point when a commitment will have to be made to pay the money. At present, we have no assured source of funding for it. So you were getting now to the stage of being able to sign off the agreement with the plaintiffs, but you now didn't have the money to pay. And if we go to the third page, there's various suggestions in this briefing as to arguments that should be put forward to the Treasury. Paragraph 8 says this: nevertheless, the advice of officials must be that the Chief Secretary be asked again to make these resources available. The arrangement made by Secretary of State last November was on the understanding that the costs would be met from the reserve and not at the expense of patient care. It must be doubted whether any agreement would have been reached to announce the offer had it not been understood that the Treasury offer was a firm one. The fact is that the Chief Secretary is reneging on the deal he struck last year, and he should be pressed to stick by it. And was that an accurate characterisation of the position as far as you were concerned?
Yes.
I don't think we need to look at the... Oh, well, perhaps we will look at the letter that was sent in response. It's by you. It's a short one. DHSC 0003662_079. Sorry, 22nd of April 1991, you to Mr. Mellor, and you say this in the paragraph numbered 2. I am very surprised that you have chosen to take this line on the haemophiliac settlement. You know that in the discussions last December, there was a clear understanding that the costs of the settlement, including the legal costs, would be met from the reserve. That was the basis on which we agreed the announcement would be made. And you must realise that I would have needed to take a different line in those discussions if that understanding had not been reached. The position was reflected in the submission at the time to the Prime Minister, which made clear that the full costs, including legal costs, would be a charge on the reserve, probably spread between this year and next. So that, I think, is the reference that you mentioned a moment or two
and
ago.
I deleted a sort of paragraph that I thought signalled a compromise, which the officials wanted me to send. I wanted it to be clear.
Is very surprised something of a polite way of saying very cross?
Yes.
There's an internal Treasury minute. I'll just pop it up on screen shortly. It's HMTR 603_002. You obviously would not have seen this. It's from a GF Dixon to Mr. Grice and to the Chief Secretary to the Treasury, 29th of April 1991. But it makes some observations about your stance. If we turn, paragraph 2 refers to it being you being anxious for a reply, and then if we go over the page, paragraph 5 refers to essentially the exchange of correspondence, and picking it up in the last sentence of paragraph 5, it says Mr. Waldegrave has not responded well to this suggestion and believes you are going back on an earlier commitment. And then paragraph 8, top of the next page, please, Lawrence, refers in the second sentence, the second sentence, third line, to an understanding that you feel strongly about it. I think you tell us in your witness statement that this is civil service terminology denoting that you were really pretty cross indeed.
Yes, and I read this letter, as I think I said in my statement, as an official in the Treasury saying to his minister, come off it, actually. He's quietly advising him to stand down, I think.
There are some further materials, but I don't think we need to go through them in any detail. The upshot on the 1st of May, DHSC 0003100_001, and this is a letter from Mr. Mellor to you, dated the 1st of May. The upshot is essentially that Mr. Mellor relents. If we look at paragraph number 3, he says, I can see advantage in reaching agreement quickly on this. I understand from my officials that you are under some pressure to conclude the settlement soon. In this instance, despite the pressure on the reserve, I am therefore willing to assist you by giving access to the reserve for a maximum of £47 million. This would comprise the £42 million payment to the Macfarlane Trust and £5 million towards plaintiffs' legal costs. I would expect you to share the legal costs with Peter Brooke, that's the Northern Ireland Secretary, and Ian Lang, so Scotland, on an equitable basis. If any future costs arise in connection with the settlement, such as further payments to unknown claimants who may come forward, I would expect you to absorb them within your existing provision. And then over the page, Mr. Mellor suggests that in offering the £5 million, he's responding more generously than he needs to, because having won the war, he doesn't want us to lose the peace. So the outcome of this spat, whatever one wants to call it, is you got the the continued availability of the reserves for the next financial year for the 42 million and 5 million from the reserves for the legal costs.
Yes, and I think looking at these papers again, it reminds one that this settlement needed careful shepherding all the way through to make sure that bits didn't get cut off it.
I think you said in your witness statement that there was no question from your perspective of backing out of the settlement, but of course you could not have gone through with the settlement if you didn't have the money.
No, because you need permission from the Treasury. Even if I'd miraculously, or if I'd cut some other programme to pieces and put the money in here, I would have needed permission from the Treasury to do that.
How does the Treasury's stance, as revealed in the communications that we've looked at, fit in your view with the idea of the government having a moral responsibility or moral obligation? Is this a dispute that reflects well on the government?
Well, clearly I think that my stance reflects better, because it was my stance. That sounds self-serving. Obviously, I thought I was in the right. But I don't blame... It's holding back the growth of public expenditure is the most thankless task. So, and it's not an amoral task to do it. So that I do not, in one sense, blame Mr. Miller or the Treasury from trying all the time to see if they can save some money. On this occasion, they were doing something which wasn't going to wash, and they backed off.
Just then want to come on to fairly shortly, we can take that down, thank you, Lawrence, the negotiations over the final settlement terms. If we pick it up at your statement, WITN 5288001, and we go to page 67, you tell us at paragraph 4.84, top of the page, I would not have been involved in the details of the negotiation. My expectation would have been to be advised if there were any important difficulties arising. Mr. Dobson's minute to Mr. Alcock of the 18th of April 1991, which we'll look at in a moment, is an example of exactly that occurring. He updated me on the position reached on the negotiations and provided me with a list of the main issues that were outstanding. And then the next paragraph, you say, as was conventional, briefing would also have been provided if media articles raised new points or allegations. Mr. Canavan's minute of the 8th of April to Mr. Ahern in my private office is an example of that, as he was addressing the Daily Mail's allegations of government delay. It would have been natural and I think correct for me to ask whether there was any substance in a media accusation of this kind. It is certainly not unknown for the media to uncover failings in a department. And if I can just ask you on that latter issue to look first of all at DHSC 0002433_018. DHSC 0002433_108. My apologies. We don't need to look at the detail of it. The headline, I think, is sufficient for present purposes. Red tape holds up £42 million AIDS payment. So that's one of a handful of articles, I think, that were flagged up in the internal departmental minutes. If we look at, next please, Lawrence, DHSC 0020822_075. This is a minute from Mr. Dobson to your Principal Private Secretary, Mr. Alcock, 15th of April 1991, and we can see it says you asked for briefing on the Sunday Times article alleging that government red tape and legal wrangling has held up payment of the £42 million settlement. I'm not going to ask you about the detailed response, but if we could just go to the bottom of the page. It says this, S of S, so that's you, asked if we should put up a government lawyer to put the department's side of the story. I would advise against this, although I think we have a good story to tell on this issue. The public is not disposed to believe the government's case. I suggest that the best course would be for ministers to say in general terms that the government has done all it can to speed the settlement. Given goodwill on both sides, payments could begin within a couple of weeks, i.e. within days of the court hearing on the 1st of May. So just going back to the previous page, please, Lawrence. Is it right to understand, first of all, this then is an example of the kind of issue that would come to your attention in terms of the detailed sorting out of the final terms of settlement?
Yes, I mean, presumably I'd read the Sunday Times and wanted to know, well, clearly I wanted to know whether there was any substance in it. When I found there wasn't, I thought that, or at least I was convinced there wasn't. I thought it was therefore an unfair attack on the department's lawyers and wanted them to be allowed to defend themselves.
And the reference to having a good story to tell, did you understand that simply to be essentially the department's not to blame for the hold-up?
Yes, and I would have had some discussion with officials about this, I suspect. And they put forward convincing reasons why it was quite complicated and why they weren't to blame. And sometimes it's very difficult. One wants, because government is always on the receiving end of criticism, but sometimes one wants to defend one's officials or allow them to defend one themselves.
So the other example given in your statement of a matter being brought to your attention for you to be kept informed of developments was the 18th of April minute from Mr Dobson. If we could have that on screen, it's DHSC 0003662_124. So we can see under the heading Summary and Recommendations, it's a submission inviting you to authorise the making of the final offer and the making of the actual payments. And the suggestion is there that they're made to individual payments on receipt of a letter of discontinuation rather than wait until a preset number of such acceptances have been received. And I want to unpick that with you as we look further down the document. The present position is set out in paragraph 1. Detailed negotiations on the terms of settlement have reached the point at which, in our judgment and that of the majority of the plaintiff's solicitors, no further worthwhile progress is likely. And then the last sentence of that paragraph reads, a detailed note on the 4 main points at issue is at Annex A, and we'll look at that in a moment. If we then go to the bottom of the page, paragraph 3, our advice is that the time has come to call an end to the negotiations and that a final offer should be made. Once payments have begun for the great majority of plaintiffs, we believe that there will be great pressure on any remaining waverers among the provincial solicitors to fall into line. The only significant issue on which any dissidents might still be looking for further concessions is on the question of social security disregards for money inherited from a haemophiliac or other primary beneficiary, and a little further detail is given about that. And then paragraph 4, the offer letter as drafted does not make the offer conditional on any particular number or percentage of litigants accepting it. This means in effect that we would be able and obliged to pay out to individual plaintiffs on receipt of a letter from them accepting the offer and agreeing to discontinue the action against the central defendants. Proceeding in this way entails a theoretical risk that the number of acceptances might fall short of the 95 to 99%, which ministers had in mind when the decision was taken to offer a settlement. In practice, we believe that the vast majority of plaintiffs will accept the offer, building in some form of threshold condition into the offer letter so that payments could only begin when, say, 95% of plaintiffs had accepted, would be seen as grudging and would seriously delay making any payments. We therefore recommend that the offer letter should be unconditional. And this was, I think, advice that you accepted, Lord Waldegrave. So in terms of the position of the plaintiffs, is this right? The department did not impose a requirement that every plaintiff must accept the terms of settlement before any individual payments could be made. But it did so recognising that the practical reality was there would be, essentially, I think the phrase is great pressure on waverers to accept.
I think we say right at the beginning that there will be no requirement that every single one should accept. I don't think, I think these 95 to 99%, which ministers had in mind, well, did we have it in mind? Perhaps we did. I think I don't remember that actual number being produced anywhere. We assumed that the great majority, as we'd been advised by the council, would accept, as they think they did.
Was it recognised within the department, recognised by you, that although the department wasn't imposing any condition of everyone accepting or any requirement of a certain number who had to accept before payments would be made, the practical reality was there was no real choice for the individual plaintiffs?
As I understand it, if the plaintiffs, if the victims' counsel recommended that this was a fair settlement, then they would be under considerable pressure because plaintiffs' counsel was a duty bound to say that to the legal aid board.
Yes. So in reality, individuals who held out would find themselves in a position of having to continue litigation with no legal aid funding and no legal representation.
That's so, yes. I mean, that is, I suppose, another way of defining the term, which is a difficult term to define, fair settlement. Fair settlement was one which had to convince their counsel, and their counsel had to be convinced of it enough to talk to the legal aid board.
The annex that's referred to in this minute is at DHSC 0003662_091. So these were the main outstanding issues. I don't need to ask you about the detail of any of them, Lord Waldegrave, but I put this up on screen just so that we can see the factual position. What was said to be the main issues holding up the conclusion of the settlement were categorisation of plaintiffs, and that's working out whether an individual plaintiff fell within a particular category that would attract X amount of money as opposed to Y. The clinical negligence cases, so those are those who had specific claims against health authorities. 3 is an issue about legal aid clawback. And then 4, the issue about social security disregards, and that was the outstanding issue about inheritance and the implications of that in terms of social security. So if we just then go to the bottom of the page of these issues, the only real remaining difficulties are over item 2, that's the clinical negligence cases, and 4, that's the social security disregard. And then it concludes, in our view, therefore, the time has come to call a halt and to conclude the main settlement so that payments can begin as soon as individual plaintiffs have accepted the offer. I flag that up as the identification of the outstanding issues because it'll be relevant to a topic I want to come back to, but there's no particular question I need to ask you relating to that. If we then just go to DHSC 0003662_080, this is your Principal Private Secretary responding on your behalf, 22nd of April 1991. It says in the first paragraph, as you will have inferred from this morning's discussion, the Secretary of State is content for you to convey the government's final offer as soon as possible to the plaintiff's solicitors and for payments to be made on receipt of a letter of discontinuation. So you are essentially authorising the go-ahead, is that right?
Yes, and beginning to worry about the transfusion payment.
Yes, so that's the other reason for looking at this. It's a topic we'll come back to, but it was also agreed this morning that you would let the Secretary of State have a detailed note on the position of the other patients who are alleged to have been infected by contaminated blood but are not haemophiliacs, and we will obviously come back to that. Just to complete the chronology in terms of the settlement of the litigation, there are two statements in Parliament. Lawrence, we don't need to put up the next document, so I'll just give the reference for the transcript. DHSC 0032157_112 is a written answer given by you on the 3rd of May 1991, announcing the making of the formal offer. There is then a more detailed written answer from you, and if we can have this on screen, please, Lawrence. It's DHSC 0002451_011. We can pick it up at the bottom of the left-hand column, where it says, Mr. Waldegrave, I welcome the announcement today in court of the conclusion of this litigation and the acceptance of the terms of a settlement by the overwhelming majority of those in England and Wales who were pursuing action. We then see the figures set out, the individual figures now set out, payments of ranging between £21,500 to £60,500, depending upon the category there. And then if we go to the next page, top of the next page, payments there for what were described as infected intimates of 23,500 or 21,500, and then the category G plaintiffs, those who had not seroconverted but were at risk of doing so, payments of 2,000. If we can then just go down, so we have the whole of the paragraph beginning while maintaining its denial of any negligence. So you say this in the written answer: while maintaining its denial of any negligence, the government had provided £42 million to cover the cost of the payments. This is in addition to the £24 million made available in 1990 to provide a sum of £20,000 for each HIV-infected haemophiliac. We're also committed to ensuring that the original Macfarlane Trust, set up in March 1988 with the government grant of £10 million, will continue to be able to give additional help where there is special need. These payments are in recognition of the very special and tragic circumstances of the haemophiliacs infected by HIV and provide a substantial measure of financial security for them and their families. It's just that last sentence I want to ask you about, Lord Waldegrave. First of all, the statement in Parliament that these are payments in recognition of their very special and tragic circumstances, is that effectively an attempt to publicly state the ring fence?
Yes, I guess so. Yes, I think it is, yes. Or repeat it because it had been established by the...
And then the suggestion provides a substantial measure of financial security for them and their families. Would it be fair to say that the sums of money involved, and we saw them set out earlier in your answer, although greater than the individual sums that had hitherto been provided, were not of a magnitude that were going to provide any real degree of financial security?
Well...
in the real world?
It's a very difficult question to answer that, isn't it? We were giving the measures, there were two ways of measuring. One was, as I keep repeating, that it came back, that it was what had been suggested.
Yes.
The other was to try and keep a little bit of an eye on what other countries were doing. And this was comparable of the better schemes elsewhere in the world. Substantial measure, it's about, I think there's been about 100% inflation since then. So these are not trivial sums, but nothing is going to compensate, of course, for the horror, but they will give valuable help.
But if we're looking at, for example, the payment that might be made to a single adult of £23,500, that might not even be what, with in good health, an individual might have earned in a single year.
The other thing to remember is that unusually, I guess, for something which is an out-of-court settlement in the normal sense of the word, in the ordinary sense of the word, is that we were not saying that there would be no further payments. And there were indeed further payments, some immediately, small ones, admittedly, to the McFarlane Trust. But this wasn't the end of the story.
Can I then, before we leave the HIV haemophilia litigation altogether, just deal with two further topics. The first is the issue of the waiver in relation to future hepatitis claims. And the second issue will just be to look a little more at some issues arising in relation in particular to Scotland. So if we go, please, to HSOC 00237174, please, Lawrence. So this is a letter of the 1st of May 1991 sent by Mr. Powell in the Solicitor's Office, the Department of Health Solicitor's Office, to the plaintiff's solicitors. It attaches the proposed final terms of settlement. And if we go to page 20, if we pick it up in paragraph 5, so about halfway down the page, you'll see there, Lord Waldegrave, the reference to discontinuing their actions against all defendants and then undertaking not to bring fresh proceedings against any defendant or against any other government department, health authority or treating doctor in respect of the administering prior to the 13th of December 1990 of cryoprecipitate factor 8 or factor 9, save that. And then one deals with what we've been termed the clinical negligence claims. And then 2, nothing herein shall prevent a plaintiff from bringing proceedings in respect of the administering prior to the 13th of December 1990 of cryoprecipitate factor 8 or factor 9, where the damage alleged does not include infection or the risk of infection by HIV and or the hepatitis viruses. So essentially, in more prosaic terms, the plaintiffs had to agree that they could not bring any fresh proceedings based upon infection with HIV or hepatitis. That's what's been referred to in some of the evidence as the waiver or undertaking.
Waiver, yeah.
There's a further document, I don't think we need to look at it, but it's for the record, it's MACF 5086_225, which is the undertaking that individuals had to sign to submit to the McFarlane Special Payments Number 2 Trust for the payment. Now, you're clear in your witness statement that the detail of the undertaking and the fact that it came to cover, as we see here, hepatitis infection was not, as far as you can recall, or as far as you can understand from the documents, drawn to your attention?
No, I mean, if it had been a contentious matter, presumably it would have, first of all, been drawn to my attention in that minute of Mr. Dobson's of the 13th of April, or otherwise. And I don't remember it being drawn to my attention at all, let alone as a contentious matter. I think, just if I can speak, I was in danger as a layperson speaking of legal matters, but I think if I thought of an out-of-court settlement, that is what I thought it meant, that you gave up you settled the matter out of court and you didn't continue with the legal action. But I'm not sure whether that's legal language. The only further point I'd make is, of course, that it was open to the government and open to the victims to make a case for further payments to the McFarlane Trust.
And you have said in your statement that a general concept of a waiver was touched on in, I think, a couple of the submissions that you saw, but nothing that flagged up any issue about either the inclusion or the exclusion of hepatitis.
No, that was never flagged to me at all.
You've, again...
I'm not quite sure where the waiver comes from. obviously read Mr. Justin Fenwick's evidence, where he suggests it comes from the other side, but I don't know.
No, and for that reason, I'm not going to try and unpick that with you.
Yeah.
It's hopefully a matter for further investigation by the inquiry. One of the matters I've been asked to explore with you, Lord Waldegrave, is to explain why there has been a sense of unhappiness or grievance about the inclusion of this waiver, and invite you to comment on it. And I'll try and do that without, I think, the need to go to any documentation, so we can take that down. The evidence the inquiry has heard might well suggest that many, perhaps most, of those haemophiliacs who were part and parcel of the settlement had either not at this stage been tested for hepatitis C, or if they had been tested, those test results had not been given to them. And there is also evidence the inquiry has received to suggest that many of those had not had the seriousness or potential seriousness of hepatitis C explained to them by their doctors. And so the concern, in a nutshell, is that many who accepted this term, signed the agreement, signed the undertaking, did so not knowing the significance of what they were relinquishing to them. Against that background, and I accept that this is not a matter that the evidence suggests was drawn to your attention at all at this time, do you think that the government should have taken steps to assure itself that those accepting these payments, not all of whom I think were plaintiffs to the litigation, were aware of what they were giving up?
I'm afraid I find that an impossible question to comment on without major research of my own.
In that case, I'll leave that there. So the last topic on the HIV haemophilia litigation, therefore, relates just to some implications in Scotland and Northern Ireland, and some of specific issues that arose there. I think if we can start by reference to your statement, so back to WITN 5288001, please, Lawrence. And if we go to page 73, you say this in paragraph 4.99, and this is about the extent to which the Secretaries of State for Scotland, Wales and Northern Ireland were involved in the negotiation and settlement process. Officials would, I hope, have coordinated with their territorial opposite numbers. In addition to that, looking at it now, I expect that I would have had some informal contact with Scottish, Welsh and Northern Irish Secretaries of State, but I cannot assert that I did in fact do so, and I have no positive memory of it now. I note that the surviving records show that the focus of consultation, which was fast-moving, was between my department, number 10, and the Chief Secretary to the Treasury. The papers show that the English legal cases were more advanced than those in the other countries, but that the assumption was that we would proceed on a UK-wide basis. Unless I was informed to the contrary by my officials, I think I would have assumed that this was acceptable to the other territorial departments. So I'll pick up on a handful of the documents, but is it right to understand from this that you didn't have any particular knowledge of the state of litigation in anywhere other than England or England and Wales?
I don't, and nothing that I can remember. The difficulty, and it's an inevitable difficulty for any inquiry or for any biographer or anything, of having to deal only with the paper records. It's rather like trying to understand an opera with just from the libretto. There were constant discussions between ministers in live time, not annotated anywhere. The discussions that take place outside cabinet were often crucial, where you met colleagues. So I cannot remember any such, but it would have been, I'm sure that we were not all mute.
And then I think if we can look at a minute from Mr. Heppel, it sets out an overall summary of the position as at December 1990, DHSC 0003664_173. So this is to Mr. Ulcock, your Principal Private Secretary. One, this is to keep you up with the state of play. Two, the steering committee with whom we have been dealing covers England and Wales, but not Scotland and Northern Ireland. The litigants in England and Wales are much further down the track. In Scotland, there are about 70 to 80 cases registered with the Macfarlane Trust, and in Northern Ireland, about 16. Writs have been served, but there have been no hearings. Neither the Scots nor the Irish have an equivalent steering committee, no doubt because there are many fewer claims. The Scottish Home and Health Departments and the Northern Ireland Department of Health and Social Services are therefore dealing with the lawyers direct. We have been working on the basis that, as before, the matter will be settled on a UK basis. If the Scots decided not to settle on the same basis as the English and Welsh litigants, we might have a handling problem, but we doubt whether this will happen. We would not release any of the money to Scotland or Northern Ireland until the litigants had signed up to the same arrangement as in England and Wales. If the Scots did not do so, the offer would be taken off the table for Scotland, and the Scots litigants would run the risk of not getting anything. In terms then of liaison with solicitors in the different parts of the United Kingdom, would it be right to understand that this minute would set out essentially the information available to you? You wouldn't expect to have any more detailed knowledge of that?
No, I wouldn't. I wouldn't, no.
In terms of where the funding would come from, it's right to understand that funding for England, Wales, Northern Ireland and Scotland, the expectation was that that would all come from what you were negotiating with Mr. Mellor, is that right?
Yes, and you remember that the Prime Minister, when he made the announcement, said this will be a United Kingdom-wide settlement.
So there was no expectation in terms of the settlement figure. We can leave aside the issue relating to legal costs that we've looked at in passing. There was no expectation of any contributions from what is referred to in the contemporaneous documentation as the territorial departments. No expectation that their budgets would be contributing to the funding of the settlement.
No.
And then I think we can probably therefore take the remaining documents, I hope, fairly quickly. You received a letter from Ian Lang in January 1991. It's at DHSC 0003660_009. So dated the 17th of January, paragraph 1 refers to the announcement on the 11th of December, and the second part of that paragraph sets out Mr. Lang's understanding that the £42 million is intended to cover the United Kingdom. Mr. Lang then says in the second paragraph, there are separate Scottish legal actions for compensation, but these have not progressed as far as the English claims. The Scottish lawyers concerned were not represented on the steering committee and have not been party to the preparation of the proposals, nor involved in the discussions which have taken place with the steering committee. This has placed the Scottish office in a difficult position, since all the discussions on the details of the settlement have been in relation to the English plaintiffs, and there have already been representations made to me by the Scottish lawyers that they were not consulted before the offer was made public. They consider that they are not in a position to advise their clients on acceptance or otherwise until they know and can assess the contents of the offer and conditions of acceptance, but also until they have fully investigated their clients' claims. It's not been possible as yet to let them have sight of the heads of agreement, since this is still to be finalised for the English litigants, and will, because it's drafted in the context of English litigation and in effect as a response to an initial approach by the English steering group, require thereafter to be revised in order to convey the offer properly for Scotland. My officials have been liaising with yours, and it's hoped to let the Scottish lawyers have a Scottish draft soon. And then there is a suggestion that because of the need to, if you could just go over the page, the Scottish lawyers to assess the acceptability of the proposals, then there needs to be an investigation of the claims. This would take some time, would conflict with the shorter timetable, which I understand is being proposed for acceptance of the offer by English plaintiffs. Clearly, we would wish to move in step with you and other parts of the United Kingdom in making the offer formally, but if a common date for acceptance is imposed, there is a risk that the government would be criticised by the legal profession and the public in Scotland for attempting to steamroller the settlement without giving an opportunity for adequate investigations of the value of the claims by the legal representatives of claimants and the consequent wisdom of acceptance of the offer, opportunities which were given to claimants in England. And then there is a request for a degree of flexibility for the particular Scottish position. Before I ask you a question, if we then just look at your response.
There must be a small misprint. There must be opportunities which were given to claimants in England.
Yes, we were given rather than were given, yes. And then if we just have DHSC 00414337_058 on screen. This was your comment conveyed to Mr Dobson in a minute dated the 21st of January from your Principal Private Secretary. I suppose this is okay, but I'm nervous about the suggestion that there should be some flexibility for the particular Scottish position. Flexibility must not mean that the Scottish offer is more generous or it will reopen the whole thing. Lord Waldegrave, I'm asked to ask you, looking back now, should further efforts have been made to involve representatives of the Scottish litigants at an earlier stage, rather than effectively and even more of a fait accompli?
It would have been very difficult, though, wouldn't it? Because there was no unified steering group to engage with, or unified group of counsel to engage with. I'm sure in those very rapid 2 or 3 days when we settled the deal for the UK overall, it would have. I hope that officials were warning Scotland that what was happening. I expect they were, but it would have been very difficult to slow it all down, I think then. But of course, in one sense, one must say, better coordination is always a good thing.
And I think you deal with the matter in this way in your witness statement, WITN 5288001, page 74. Paragraph 4.101, so bottom of the page. You say this: while I do not recall this issue having prominence, I expect that we could have handled this better, and I include myself in that. Certainly, from the records to which the inquiry has directed my attention, there would appear to have been little formal involvement of the Scottish and Northern Ireland offices early in the process. I can only assume that this arose because the English cases were more advanced, and perhaps because of the fast-moving nature of the liaison between the Department, the Treasury and Number 10 to secure the settlement. I cannot imagine that any conscious decision would have been taken not to involve the Scottish and Northern Ireland offices, but from the records I have been shown, perhaps we should have involved them earlier, having regard to their own litigation and the plaintiffs involved there, but I think it very likely there were informal discussions between Secretaries of State.
I think that's fair, yeah. I think that's right.
There's one final issue relating to the position in Scotland. I'm not going to ask you about it now, Lord Waldegrave, because your evidence suggests that this wasn't a matter that came before you. You deal with it in paragraph 4.104 of your witness statement, page 75. And the relevant references to the documents are set out in that paragraph, so that there's no mystery about what was being discussed there. An issue was flagged in October 1991 by Mr Tucker of the Scottish Home and Health Department about category G individuals. And because of the way Scotland's involvement had lagged behind the involvement of plaintiffs from England and Wales, there was a risk that people might be excluded from Category G in Scotland when they wouldn't necessarily have been excluded in England and Wales.
I understand that issue, yeah.
And there's some correspondence, the details are there set out between Mr Tucker and Mr Dobson, but that didn't come before you as far as you know.
I certainly wouldn't have had direct memory of it now, but there seems to be no evidence that it did.
So I'm going to move next to the issue of those transfused, those infected with HIV as a result of transfusion.
Yes.
What I was going to suggest, because I won't complete that today, if we took our break now for half an hour and then come back and I can make a good start on it as a new topic before we finish and then pick it up to complete in the morning.
Yes, well, very good. We'll take a break then now until 3:30 and then come back.